The parties are presently engaged in an intense armed conflict that has led to a tremendous loss of life and great human suffering. Nevertheless, with regard to the situation in eastern Ukraine and in the Crimean Peninsula, the case before the court is limited in scope and is brought only under the provisions of the ICSFT and CERT. The court is not called upon to rule in this case on any other issue in dispute between the parties. With regard to the ICSFT, the applicant instituted proceedings relating to the events in eastern Ukraine, alleging that the Russian Federation failed to take measures to prevent and suppress the commission of offenses of terrorism financing. In particular, the applicant refers to acts and armed activities in eastern Ukraine allegedly perpetrated by armed groups linked to two entities that refer to themselves as the Donetsk People's Republic, or DPR, and the Luhansk People's Republic, or LPR. Other acts to which the applicant refers were allegedly perpetrated by armed groups and individuals in other parts of Ukraine. With regard to CERT, the applicant refers to events which took place in Crimea from early 2014, after the Russian Federation took control over the territory of the Crimean Peninsula, alleging that the Russian Federation has engaged in a campaign of racial discrimination, depriving Crimean Tatars and ethnic Ukrainians in Crimea of their political, civil, economic, social, and cultural rights in violation of its obligations under CERT. The court recalls that in its judgment of 8 November 2019 on preliminary objections, it considered that the dispute consists of two aspects. The first relates to the ICSFT, and the second relates to CERT. The court further stated that in the present proceedings, Ukraine is not requesting that it rule on issues concerning the Russian Federation's alleged aggression or its alleged unlawful occupation of Ukrainian territory, nor is the applicant seeking a pronouncement of the court on the status of the Crimean Peninsula under international law. These matters do not constitute the subject matter of the dispute before the court. In the same judgment, the court found that it had jurisdiction on the basis of Article 24, Paragraph 1 of the ICSFT and Article 22 of CERT to entertain the claims made by Ukraine under these conventions. Thus, the jurisdiction of the court is limited to the alleged violations by the Russian Federation of its obligations under the two instruments invoked by Ukraine, and does not concern the conformity of conduct of the Russian Federation with its obligations under any other rules of international law. Before addressing Ukraine's specific claims under the ICSFT, the court considers the Russian Federation's objection based on the clean hands doctrine, which in the court's view was invoked as a defense on the merits. The court considers that the clean hands doctrine cannot be applied in an interstate dispute where the court's jurisdiction is established and the application is admissible. Accordingly, the invocation of the clean hands doctrine as a defense on the merits by the Russian Federation must be rejected. The court then turns to the interpretation of certain provisions of the ICSFT, starting with the meaning of the term funds. Under Article 2, Paragraph 1 of the ICSFT, the provision or collection of funds is a constituent element of the offense of terrorism financing, the actus reus. The term funds is defined in Article 1, Paragraph 1 as meaning, I quote, assets of every kind, whether tangible or intangible, movable or immovable, however acquired, and legal documents or instruments in any form. End of quote. The terms funds and assets of every kind in the ICSFT are to be interpreted in accordance with the rules of treaty interpretation stipulated in Articles 31 to 33 of the 1969 Vienna Convention on the Law of Treaties. The court first turns to the text of Article 1, Paragraph 1 of the ICSFT. The definition of funds in that paragraph begins with a broad reference to, I quote, assets of every kind, whether tangible or intangible, movable or immovable, however acquired, end of quote. The rest of the paragraph provides a non-exhaustive list of documents or instruments that may evidence title to or interest in such assets. While the phrase assets of every kind is an expansive one, the documents or instruments listed in the definition are ordinarily used for the purpose of evidencing title or interest only with regard to certain types of assets, such as currency, bank accounts, shares, or bonds. The Court notes that the use of the phrase, "but not limited to," in Article 1, Paragraph 1, suggests that the term funds covers more than traditional financial assets. The term also extends to a broad range of assets that are exchangeable for or used for their monetary value. The Court then takes into account the context in which the term funds is used in other provisions of the ICSFT, which suggests that the term funds is confined to resources that possess a financial or monetary character. The Court then takes into account the object and purpose of the ICSFT. It notes that the preamble and the title of that convention suggest that the object of the ICSFT is not to suppress and prevent support for terrorism in general, but rather to prevent and suppress a specific form of support, namely its financing. The travaux préparatoires confirm the aforementioned interpretation of the term funds. In light of the foregoing, the Court concludes that the term funds, as defined in Article 1 of the ICSFT and as used in Article 2 thereof, refers to resources provided or collected for their monetary and financial value, and does not include the means used to commit acts of terrorism. Consequently, the alleged supply of weapons to various armed groups operating in Ukraine and the alleged organization of training for members of those groups fall outside the material scope of the ICSFT. In the present case, therefore, only monetary or financial resources provided or collected for use in carrying out acts of terrorism may provide the basis for the offense of terrorism financing, assuming that the other elements of the offense referred to in Article 2, Paragraph 1 are also present. Next, the Court turns to the interpretation of Article 2, Paragraph 1 of the ICSFT in order to determine the scope of the terrorism financing offense defined therein. The Court begins by recalling its previous finding in the 2019 judgment on preliminary objections that while the financing of terrorism by a state as such is not covered by the ICSFT, that convention does require states to act to suppress and prevent the commission of the offense of terrorism financing by all persons, including by state officials. The Court then considers the scope ratio materiae of the offense of terrorism financing. Multiple provisions of the ICSFT refer to the commission of offenses set forth in Article 2, including Articles 4, 8, 9, 12, and 18. The Court takes note that Article 2 sets out two kinds of offenses. First, the offense of terrorism financing, which is addressed in the chapeau of Article 2, Paragraph 1. And second, the two categories of underlying offenses or acts, which are stipulated in Article 2, Paragraph 1a and b, and to which the Court refers as predicate acts. In the view of the Court, the phrase offenses set forth in Article 2 should be understood to refer only to the offense of terrorism financing, while the predicate acts themselves are not offenses falling within the scope of the ICSFT. The Court next addresses the two mental elements of the offense of terrorism financing set out in Article 2. According to that provision, the commission of the offense of terrorism financing requires that the funds in question be provided or collected either with the intention that they should be used or in the knowledge that they are to be used in order to carry out the predicate acts. In support of its claims, Ukraine relies entirely on the mental element of knowledge. Accordingly, the Court confines its analysis to the interpretation of the phrase, "in the knowledge that they are to be used." A determination of whether the element of knowledge is present must be made on the basis of objective, factual circumstances. The element of knowledge may be established if there is proof that the funder knew that the funds were to be used for the commission of a predicate act. In this regard, it may be relevant to look at the past acts of the group receiving the funds in order to establish whether that group is notorious for carrying out predicate acts. On the other hand, the characterization by a single state of an organization or a group as terrorist is insufficient on its own to displace the need for proof of the funder's knowledge that the funds in question are to be used to carry out the predicate act. The Court then addresses the scope and interpretation of the predicate acts defined in Article 2, Paragraph 1a or b. Having already established that these predicate acts are not themselves offenses under the ICSFT, the Court only interprets the scope of Article 2, Paragraph 1a and b to the extent necessary to inform its conclusions regarding the alleged violations by the Russian Federation of its obligations with respect to cooperation in the prevention and suppression of the offense of terrorism financing. The category of predicate acts specified in Article 2, Paragraph 1a, is defined by reference to the treaties listed in the annex to the ICSFT. With respect to the category of predicate acts specified in Article 2, Paragraph 1b, the Court notes that it is not enough for deliberate killings or serious bodily harm to civilians to have occurred. It is also essential to demonstrate that, I quote, the purpose of such act, by its nature or context, is to intimidate a population or to compel a government or an international organization to do or to abstain from doing any act. End of quote. The Court next recalls that the question before it is whether the respondent has violated its obligations under the ICSFT to take measures for and to cooperate in the prevention and suppression of terrorism financing, including by acting to freeze the accounts of suspected terrorism financiers, assisting in the investigation of such offenses, initiating prosecutions, or otherwise taking practicable measures to prevent the financing of terrorism. Answering this question requires the Court to interpret and apply obligations under Articles 8, 9, 10, 12, or 18 of the ICSFT. In so doing, it will be guided by its interpretation of Articles 1 and 2 of that Convention, in particular the term funds. Consequently, it is not necessary for the Court to evaluate predicate acts, the commission of which is sustained solely by the supply of weapons or other means used to commit such acts. The Court further recalls that the offense of terrorism financing is distinct from the commission of predicate acts. In order to decide on the alleged violation of the obligations invoked by Ukraine, it is not necessary for the Court to first determine whether the specific acts alleged by Ukraine constitute predicate acts. Finally, the Court notes that it does not have sufficient evidence before it to characterize any of the armed groups implicated by Ukraine in the commission of the alleged predicate acts as groups notorious for committing such acts. Accordingly, to establish the element of knowledge, it must be shown that at the time the funds were allegedly collected or provided to the groups, the alleged funder knew that the funds were to be used to carry out predicate acts. The Court next addresses certain questions of proof. It states that in deciding Ukraine's claims under the ICSFT, it will determine whether the evidence adduced by Ukraine is convincing. The Court also notes that each provision of the ICSFT invoked by the applicant imposes a distinct obligation upon states parties to that convention. In each case, the Court must first ascertain the threshold of evidence of terrorism financing that must be met for an obligation under that provision of the ICSFT to arise. If the Court finds that for a given provision of the ICSFT, the relevant obligation did arise for the Russian Federation, it must then determine whether the Russian Federation has violated that obligation. The Court then turns to the examination of the alleged violations by the Russian Federation of its obligations under the ICSFT, starting with Article 8 thereof. Article 8 of the ICSFT imposes upon states parties various obligations, inter alia, to identify, detect, freeze, or seize funds used or allocated for the purpose of committing the offenses set forth in Article 2 of the ICSFT. The applicable evidentiary threshold under Article 8 of the ICSFT may differ depending on the scope and nature of the precise obligation at issue. For instance, the obligation to identify and detect funds allocated for the purpose of terrorism financing entails a lower threshold than the obligation to freeze such funds. Since the applicant is primarily concerned with the alleged non-compliance by the Russian Federation with its obligation to freeze certain funds, it is necessary to ascertain the evidentiary threshold required for a state party to the ICSFT to be required to freeze funds alleged to be used or allocated for terrorism financing. The Court is of the view that the obligation under Article 8 to freeze funds only comes into operation when the relevant state party has reasonable grounds to suspect that those funds are to be used for the purpose of terrorism financing. The Court notes that this standard is in line with that adopted by the Financial Action Task Force in its special recommendations on terrorist financing. The Court also notes that the obligations under Article 8 are not contingent on a state party receiving information from another state party. In the present case, however, Ukraine's arguments primarily relate to the communications it submitted to the Russian Federation regarding the alleged use of certain funds and accounts for the purpose of committing offenses under Article 2. The Court therefore focuses its analysis on these communications. The Court states that of the note verbale and requests for legal assistance submitted to it by Ukraine, only 4 contain descriptions of specific persons and accounts alleged to have been associated with the financing of predicate acts under the ICSFT. The Court concludes that these note verbale do not contain sufficiently specific and detailed evidence to give the Russian Federation reasonable grounds to suspect that the accounts, bank cards, and other financial instruments listed therein were used or allocated for the purpose of committing the offenses under Article 2 of the ICSFT. The Russian Federation was thus not required to freeze those funds. In light of the foregoing, the Court concludes that it has not been established that the Russian Federation has violated its obligations under Article 8, Paragraph 1 of the ICSFT. The Court next considers Article 9 of the ICSFT, which concerns the obligation of a state party to investigate allegations of the commission of terrorism financing offenses by alleged offenders present in its territory. The Court notes that the threshold set by this provision is relatively low. For the obligation to investigate to arise, Article 9, Paragraph 1 requires only that a state party receive information that a person who has committed or who is alleged to have committed the offense of terrorism financing may be present in its territory. In circumstances where the information only alleges the commission of an offense under Article 2, it is not necessary that the commission of the offense be established. Indeed, it is precisely the purpose of an investigation to uncover the facts necessary to determine whether a criminal offense has been committed. Moreover, credible information received from any other source may give rise to the obligation to investigate. At the same time, however, the Court considers that Article 9 does not require the initiation of an investigation into unsubstantiated allegations of terrorism financing. If a state party has received sufficient information of alleged terrorism financing committed by an individual present on its territory, it is required to undertake a meaningful investigation into the alleged facts in accordance with the laws and procedures it would ordinarily follow when presented with information on the commission of a serious crime. Furthermore, in fulfilling its obligation to investigate, a state party must also endeavor to cooperate with any other interested states parties and must promptly inform them of the results of its investigation. The Court next considers whether the Russian Federation received sufficient information to require it to investigate any alleged offenses under Article 2 of the ICSFT. Ukraine has pointed to several note verbale sent from its foreign ministry to the foreign ministry of the Russian Federation, which, it argues, contained credible allegations of terrorism financing by individuals in the territory of the respondent. In the view of the Court, while some of the note verbale contains contain alleged facts that fall outside the scope of Article 2 of the ICSFT. Three of the documents adduced, in particular, the note verbal dated 12 August 2014 and 29 August 2014, contain sufficiently detailed allegations to give rise to an obligation by the Russian Federation to undertake investigations into the facts alleged therein. The information received included a summary of the types of conduct allegedly undertaken by members of armed groups associated with the DPR and LPR that Ukraine considered to constitute predicate acts under the ICSFT, the names of several individuals suspected of terrorism financing, and details regarding the accounts used and the types of items purchased with the funds transferred. The Court considers that such information met the relatively low threshold set by Article 9 and thus required investigation by the respondent. In light of that conclusion, the Court proceeds to determine whether the Russian Federation met its obligation to undertake a meaningful investigation into the facts alleged in the note verbal. The Ministry of Foreign Affairs of the Russian Federation first responded to the Ukrainian communications in a note verbal dated 14 October 2014. In that communication, the ministry informed Ukraine about, I quote, the need to provide the Russian side with factual data on the issues brought up, end of quote, in the Ukrainian communication. However, the Russian Federation provided no clarification as to the precise additional information that was required. Subsequently, on 31 July 2015, the Ministry of Foreign Affairs of the Russian Federation sent Ukraine a note verbal that included further details on the actions taken by the competent Russian authorities. These included the results of investigations into two of the alleged offenders. However, no clear information was provided by the respondent concerning the other alleged offenders described in the Ukrainian communications as being present in the Russian territory. The Court takes note of the amount of time that elapsed before the Russian Federation provided the aforementioned responses to the Ukrainian note verbal. In this regard, the Court observes that a 2019 report issued by the Financial Action Task Force stated that the Russian Federation generally answers requests for mutual legal assistance within 1 to 2 months. It is therefore notable that almost 1 year after receiving the Ukrainian allegations, the Russian Federation appeared to have failed even to identify several of the alleged offenders. Furthermore, to the extent the respondent encountered difficulties ascertaining the location or identity of some of the individuals named in the Ukrainian communications, it was required to seek to cooperate with Ukraine to undertake the necessary investigations and specify to Ukraine what further information may have been required. In light of the foregoing, the Court concludes that the Russian Federation has violated its obligations under Article 9, Paragraph 1 of the ICSFT. Turning to Article 10, Paragraph 1, the Court recalls that it requires states parties to the ICSFT to either prosecute or extradite alleged offenders of terrorism financing offenses under Article 2. The Court observes that the applicant's arguments appear to be limited to an alleged violation by the Russian Federation of its obligation to prosecute. The obligations found in Article 10, Paragraph 1 of the ICSFT are ordinarily implemented after the relevant state party has performed other obligations under the ICSFT, such as the obligation under Article 9 to conduct an investigation into the facts of alleged terrorism financing. In addition, Article 10 does not impose an absolute obligation to prosecute. The competent authorities of the states parties to the ICSFT retain the responsibility to determine whether prosecution is warranted based on the available evidence and applicable legal rules, so long as such decision is taken in the same manner as in the case of other grave offenses under the law of that state. The Court notes that the decision to submit a case to the competent authorities for purposes of prosecution is a serious one that requires, at a minimum, reasonable grounds to suspect that an offense has been committed. The court recalls its finding that the information provided by Ukraine to the Russian Federation did not give rise to reasonable grounds to suspect that terrorism financing offenses within the meaning of Article 2 of the ICSFT